International law nowadays is commonly made by treaties between nations. It can also arise from the established customs of nations in dealing with one another. The distinction matters. Treaties only bind the countries that sign them. Customary international law binds every country. West Germany, Denmark, and the Netherlands all had North Sea coastlines. They had agreed on coastal sea borders, but not borders on the continental shelf, which has oil and gas. Denmark and the Netherlands had signed the Geneva Continental Shelf Convention, a treaty about deciding disputed continental shelf boundaries. West Germany had not signed. The convention applied a principle called equidistance, which basically meant drawing a line equally distant to the coastal boundaries of each country. Due to the shape of the German coastline, equidistance would have given West Germany a much smaller proportion of the North Sea compared to the other two countries. Before the International Court of Justice, Denmark and the Netherlands argued that the Geneva Continental Shelf Convention had been applied so broadly that it was now customary law, binding on West Germany. The court considered how treaty law can become customary international law. They said, there is no doubt that this process is a perfectly possible one. At the same time, this result is not likely to be regarded as having been attained. They considered several factors. First, whether the treaty created an equidistance rule at all. This was doubtful because the treaty required countries to negotiate an outcome and only applied equidistance if they could not. The treaty also allowed divergence from equidistance in special circumstances, so there was no clear rule. Second, the court considered that for a treaty provision to become a customary rule, there would have to be broad acceptance of the rule, even by countries outside the treaty. There was no evidence of that in this case. Finally, even if equidistance had become the common method, there would have to be evidence that the states were applying that method from a sense of legal obligation. The court said the states concerned must therefore feel that they are conforming to what amounts to a legal obligation. The frequency or even habitual character of the acts is not in itself enough. As a result, the treaty did not apply, and there was no customary law, so the three countries had to return to negotiations and sort it out amongst themselves.